Hello, everybody. I'm going to start, welcome everybody. I'm going to start with a short presentation or with a short few sentences in French before I move on to English, which is going to be the language of the presentation. Alors, bonjour et bienvenue à tous et à toutes. Je veux vous dire que cette conférence fait partie du cycle de séminaires du Centre Jean Monnet de Montréal. Et ce centre est financé par le programme Erasmus+, de l'Union européenne, et aussi grâce aux contributions de l'Université McGill et l'Université de Montréal. Si vous voulez avoir plus d'informations sur les événements à venir, vous pouvez aller à jeanmonnet.ca. So, hello everybody. This conference is part of the Jean Monnet series. And this center has funding from the European Union's Erasmus Plus program and is also supported by the University of Montreal and McGill University. If you want to have more information about events, upcoming events and seminars, you can check out jeanmonnet.ca. So our conference today features an excellent researcher. Her name is Anna Triandafyllidou. She's a professor of sociology at Ryerson University since 2019 and also the Canada Excellence Research Chair on Immigration and Integration. Professor Triandafyllidou previously worked as the Robert Schuman Chair at the European University Institute in Florence, and she has published extensively on immigration, particularly in the European context. I could say many more things. We'll be here for a few days talking about her work, but I don't want to take time from the presentation, so I'm just going to add that the presentation today is titled Transiting Through Libya and What the International Community Can Do, and it is based on a paper recently published in Antipode, the journal Antipode, with Katie Kushminder, who is at Maastricht University, sorry. So Anna, thank you very much. We're very lucky to have you here, and I'll give you the mic. Thank you.
Thank you very much, Luna. Bonjour à tout le monde. Comme Luna a expliqué, la présentation sera en anglais, mais je serai contente d'avoir des questions aussi en français, qu'on dira l'honneur de bilingualisme canadien. Et comme Luna a expliqué, je suis européenne et j'ai passé la grande partie de ma carrière en Europe, en différents pays, travaillant en différents pays, la Belgique, le Royaume-Uni et surtout l'Italie et l'Institut universitaire européen, mais je suis grecque d'origine. Et bon, je vais passer à l'anglais. Yes, this study is actually, let me say just 2 words without taking much time about the Canada Research Excellence Chair Program at Ryerson. I'm holding the chair and we are building a strong research program that deals with different aspects of migration and integration, including governance of migration, settlement and integration in comparative perspective, but of course issues of identity, belonging, multiculturalism, etc. So I would very much welcome hearing from you. If you have any questions, if you have any interest, you can find more in our web page, which I think is at the end of my presentation, so I'm not going to spend time now spelling it. So this paper, as Luna said, well, first of all, I want to thank Luna for inviting me. It's great to be here, and it's great to have a Jean Monnet connection also in Canada. Although actually I'm trying to learn fast more about Canada rather than further cultivating my expertise in Europe, although I should say perhaps unfortunately migration and asylum seeking keeps hitting the European headlines or the global headlines because people keep being displaced, keep seeking refuge and not having many avenues to find refuge in legal ways, and the pandemic, COVID has made things a lot worse and a lot more difficult for both international asylum seekers and internally displaced people. This paper focuses particularly on the case of Libya that I think has hit many headlines across the world in the recent at least 5 years, and I would say almost nearly 10 by now after the fall of the Gaddafi regime. I'll start sharing my presentation now. Let me just share. Yes, so as to support what I say with some visuals. And this paper is co-authored with Katie Kushminder, who is an assistant professor at Maastricht University, and at the time when she conducted the interviews, she was working with us at the UI as a postdoctoral fellow. And actually, we are now continuing this research, as I will explain in the end, because we feel there's more to be done, and probably it's very topical, even if, as we were discussing with Luna just before opening up the virtual seminar room, the EU Pact, the new EU Pact on Migration and Asylum, doesn't seem to provide solutions to the questions that we will raise today. So with Katie was conducting a study on what happens with Eritreans and Nigerians who cross through Libya and come to Italy, and she was looking to see whether these people make it to northern countries, where actually, how do they make their decisions about whether to stay in Italy, what is the role of networks, what is the role of policy implementation, where do they get their information, do they decide to go further north, as many hypothesize, and or whether they decide to stay in Italy. But of course, part of this research was very much focusing on what happens in Libya, and their testimonies were really heartbreaking about not only abuse and unfortunately torture that we've seen also in the media, but also kidnapping and extortion. And we were particularly interested in kidnapping and extortion because this is, I mean, at this scale at the scale that we've seen this in Libya, it hasn't been seen before. Both Kate and myself have worked also on, for instance, Afghan and other asylum seekers and migrants crossing through Turkey to Greece, or for instance, crossing through Morocco to Spain. But what happens in Libya is unfortunately quite unique and very tragically unique. And the question was, are people who are being abused and tortured in Libya asylum seekers or not? And what should be the basis for deciding whether they are asylum seekers? So let me just say a few words about the legal framework of this and the relevant definitions in international law. So you're probably familiar with the two Palermo protocols. So they are UN protocols signed in year 2000 in Palermo, which define smuggling and trafficking, and actually try to differentiate between these two phenomena. And again, I'll explain this in a minute. But we also looked, because there was extortion and kidnapping taking place in Libya, we also looked at something that we hadn't looked before, which is the Rome Statute of the International Criminal Court and how it defines crimes against humanity, particularly in Article 7, where there is a series of crimes that can be considered crimes against humanity, which include torture, rape, murder, also kidnapping, imprisonment. And the statute defines when this thing happens in an extensive way. This can be considered as a crime against humanity. And this, of course, how can I say, kickstarts a whole set of different legal instruments, because it is not strictly related to asylum seeking. So this is what we were looking at. Let me say a couple of words about smuggling and trafficking. And you probably are aware that these phenomena are, from a policy perspective, and if you want, from a conceptual perspective, quite distinct, even though in reality we encounter them in rather confused and how can I say, intertwined ways. So what makes them different is that, in theory, migrant smuggling is like an agreement between the migrant, the person who is interested to migrate illegally, and the smuggler, the provider of services. So it's like the person pays a certain amount of money through an agreed modality. It is often like half of the money up front and half of the money upon arrival, to the smuggler, who helps them cross the border with fake visas, fake documents, through an unguarded point of entry, and so on. The relationship is like a business relationship in theory, and it stops when the person arrives. So it doesn't involve any relationship after arrival of exploitation, etc. Obviously, the migrant has to pay the smuggler. Now, as we know, the situation is not truly like simple, how can I say, contractual relationship, because during the journey, the migrant is pretty much at the mercy of the smuggler and pretty much powerless. Also, sometimes the smugglers ask for more money that their clients cannot pay. Sometimes the clients, and we know this particularly with regard to the Libya-Italy crossings, refuse to get on boats that are really in very bad conditions and completely overcrowded, but they have little leverage to change the situation. In any case, this phenomenon is legally quite distinct from trafficking, where in human trafficking, there has to be deception. So the person is seen as a victim, not as a client, if you want. So the person engages into a relationship with a trafficker through deceit. They don't know what awaits for them. They are probably told that I'll bring you to another place or another country and I'll give you a job. I will, like a rosy generally picture is presented to them, and for which they become indebted. And most importantly, trafficking, which, by the way, does not necessarily involve the crossing of international borders. So it can happen also within a country. So then there is exploitation and abuse. So upon arrival at destination, the person is exploited by the trafficker. For instance, they work for them and the money is taken by the trafficker, and the relationship continues. So again, in theory, there's a clear distinction, but as I said, in practice, we often find that on the ground, it's very difficult to distinguish between the two situations. Now, there's probably nothing very new in what I've just said about the thin line that distinguishes between smuggling and trafficking, but I think it is worth taking a closer look at the case of Libya and what happens there, and why we found that neither smuggling nor trafficking could provide for a good definition and for a good set of legal instruments or policy instruments to address the vulnerability of people going through Libya. Now, you can see on your screens a map of Libya, and where you see the thicker red lines, this is where people come from, particularly from East Africa, but also from West Africa, going through Libya, trying to make it to the Mediterranean shores. Now, it has to be said that after the fall of certainly the Gaddafi regime was a very harsh dictatorship. It has all of the ills of the world. But what can be said is that after the fall of the regime, there's been a significant collapse of the Libyan economy and of related economic activities. There has been lawlessness. As you know, in Libya, there are two competing governments. There's been continued warfare. And of course, this has fueled both illegal trade in general, including, for instance, drugs and weapons trade, but also migrant smuggling and trafficking in human beings. Now, what we find is special about Libya is that there is no rule of law. So even to define smuggling and trafficking, you need to have a rule of law, and you need to define what is criminal activity and what is not. In the case of Libya, and particularly where one enters the country from what is the southeast, the southeast border, the tribes, and particularly the Tebu tribe that controls this territory, is at the same time the ruler of this territory as a parastate or non-state actor, and at the same time is the criminal network that enslaves people, extorts them, tortures them to get more money out of their relatives. So we are arguing that this is a situation where we can actually refer to the notion of a Agamben space of exception. So there is no rule of law, and it is very difficult to say who is actually who is the state, who is the criminal network, and in that sense, in what position do smuggled migrants or asylum seekers find themselves. It is also important to know now, going back to the definitions that I mentioned, one thing, so what happens, is this migrant smuggling, is it migrant trafficking, or is it something else? And what we have found is that people generally, I mean, what happens in Libya cannot properly qualify as trafficking in human beings, because generally people were not deceived and they were not actively recruited. So they knew the risks. They had an understanding that they would face significant risks, including women who had an understanding that they might be raped, that there was a high risk of that. But they decided to go nonetheless. Of course, the reasons why people decided, as we can see in this testimony that you can see on your screens of Emmanuel, was that people had very strong motivations for migrating, particularly Eritreans who had been living in Sudan or in Ethiopia for a while and were looking forward to build a better life for themselves and their families. And what we found in the interviews was that there was a biased processing of the information and generally a mechanism of self-deception. So I believe this is terrible, but it won't happen to me, and I will take precautions, and I will manage to survive and go through this difficult part of the journey to get to the Mediterranean and cross to Italy. And so what is important in terms of defining the status of these people upon arrival in Italy is, as I said, that there was no clear deceit, and they had some, I mean, one could say that was more similar to migrant smuggling in the sense that people had voluntarily sought for the services of the smugglers. At the same time, looking at the harshness of their experiences and the hardship, the terrible hardship that they have been through, one kind of goes back to this definition of trafficking, because it is clear that the people in the hands of this migrant smugglers or passeurs, they were totally powerless, that this tribe was quite, how can I say, well, treating them inhumanely, not considering them of any value, their lives, and killing anyone who protested. So that brought us back to the notion of trafficking. But as I said, we felt that this could not be applied for the reasons that I explained. So that's when we thought that when people, however, arrive in Italy, they've been abused, they've been tortured, they've been kidnapped, and there was an effort for their families to send money. Some of the families did send money, others didn't because they simply didn't have. And all that was happening, as I said, in a space of exception where there was no state, there were no authorities to which to turn to, and it was unclear actually what or who made the legal order. Was it the tribe itself? So the question that we have posed ourselves is, what legal instruments can we find to address this issue and provide for a status for these people upon arrival in Italy, even when these people could not show that they had been persecuted at their country of origin, which would be the main basis of asylum seeking, as we know. Now, what we have found is that in Italy there has been a trend, particularly before the end of 2018, when a new law was voted that was much more restrictive, a so-called security pact by the then right-wing government. So there was a status that was given largely to people who went through Libya, even if they did not satisfy the requirements to be recognized as asylum seekers, as refugees. And you can see here the percentages for 2017. So of course you can see that about half of the people were denied asylum. So this is the blue part of the circle, but there was humanitarian protection given to 1/4 of the people, so quite higher than refugee status and subsidiary protection. So it was about 20% in total for full refugee status under the Geneva Convention, subsidiary protection, which is, as you know, an international temporary protection to people fleeing war and violence, and then there was the humanitarian status. So I want to say a couple of things about the humanitarian status, which is the part that is not covered in the paper and is a new part that we're working on right now with Katie Kushminder and one more colleague from Italy, because we hope that there is a practice that can inform not only the Italian, but perhaps also the European legislation and practice and cover for the case of these people who are not prima facie refugees in terms of their country of origin, but have been through extreme hardship, particularly also extortion, torture, abuse, kidnapping in Libya, and who arrive in Italy deeply scarred by these experiences. So what we have found is that this humanitarian status, which is a special status in Italy, was created quite a few years back and actually is part of the comprehensive law on immigration in Italy, and it was afforded, this humanitarian status was afforded to people who were very ill or very elderly, even if they were undocumented in Italy, to mothers of newborns or pregnant women, so up to 6 months of age of the child, of the baby. And it was also actually after a related decision at the Court of Appeals in Italy of, I don't remember, I'm sorry, which year, it was given also to the spouses or partners of the mothers and pregnant women. And the status is also given to minors, in Italy, minors who arrive undocumented. So this is similar to the toleration status that is given in other EU countries to people who have no documents, but who for various reasons cannot be expelled, cannot be sent back to their own countries, and are temporarily sojourning without legal status. This status in Italy is given between 6 months and 2 years, and what is most important, it can be converted to a normal temporary migration status. So suppose the person who receives this status, including, for instance, some of our informants who were from Eritrea or Nigeria and had been through abuse in Libya, they could hold the status, say, for a year, and during this year find a job, seek to integrate in Italy, and then convert it to stay permit for work purposes and enter, so to speak, the mainstream path. What attracted our attention in the beginning was that it seemed that different courts in different regions of Italy were given this status in recognition of the hardship. So they would give the status if the first application for asylum was rejected. So upon appeal of this application, they would look at whether the person has been through Libya and has been suffering, from abuse and torture, and second, whether the person has tried to integrate in Italy. And this integration was judged in terms of whether the person could speak some Italian, whether the person could show that they have friendships in Italy, they have social relations, that they, for instance, they participate in some voluntary activity, that they have engaged into some temporary work or part-time work, that they are attending language classes or any other types of classes. So actually the panoply of ways in which a person could show their integration at court was quite large. And this gave to the courts the possibility of giving these people temporary status for humanitarian purposes. Now, in our research, we felt that this was probably a way to circumvent the law, to circumvent actually the absence of a special provision for these people, the difficulty to have them match the trafficking, the victims of trafficking preconditions, the fact that many of them were not prima facie refugees, but that they could not be sent back and that they had been through extreme hardship in Libya. Now, as I said, we are pursuing this study, and what we are finding is that what made the difference was a Supreme Court decision in Italy in 2016, which said that if the people show that they try to integrate in Italy, this should be taken into account. So in a way, this has, given a powerful instruments to judges, to courts, to provide humanitarian status for people who would not otherwise qualify either for refugee status or for humanitarian protection or as victims of trafficking. Now, what we're also finding, and this is a work in progress, is that there are very different ways in which, for instance, courts in Sicily and courts in Tuscany or courts in the Veneto region, so like south, center, and north of Italy, these are very distant regions, have been applying these discretionary measures. But what we also feel is that there is a crux, how can I say, of innovation and of evidence that such a system could work, and that both the hardship endured through the journey, through the transit journey, and the effort to integrate at the country of arrival while one is awaiting for the asylum decision are important aspects that should be taken into account when a final decision is made, for instance, of whether this person should receive temporary stay status in that destination country in the EU. And we were wondering whether what would be easier at the EU level would be to try and work on the Rome International Statute on crimes against humanity, or whether it would be easier to try and kind of scale up this Italian measure to other countries and other courts as a recognition of both the hardship and the effort of the migrant to integrate. From a sociological perspective, what we have found particularly important in this study is the role of migrant agency, or the role of asylum seeker agency, in both define risk and trying to make the journey, but also in trying to integrate at the country of destination. And actually, I will conclude that and just state that, and here's, yeah, here you can find also the website, the website address of the Canada Excellence Researcher. But returning to the study, I think we could also discuss, we could also talk a little bit about during the discussion about what does the new EU Pact on Migration and Asylum doesn't do on addressing this issue of people who are in this kind of indeterminate status between asylum seeker and migrant. And unfortunately, there are many of them that are not finding the protection they need in the EU. And I will stop at this. I will stop the sharing so we can see each other. But of course, if you need, I can put it up if you have any specific question that refers to a slide. And thank you very much, and I'll be happy to take questions.